Counsel, may I have your appearances, please?
Morning, Your Honor. Arthur Kelby for the state.
Morning, Your Honor. Sarah Weinstock on behalf of Khaleeia Bass.
Counsel, I have the following documents which I've marked. I have the complaint warrant as recited. I'll mark as S1. I have a public safety assessment dated November 3rd, 2018 at 9:56 a.m. with a recommendation of no release and a score of 6 and 6, which I'll mark as S2. And I have the prosecutor's motion, which I'll mark as S3. Stated are there any other documents?
No, Your Honor. Thank you.
Any documents from the defense?
No, Your Honor.
Defendant may have a seat.
Briefly on the date in question, which is November 1st, at approximately 8:26 p.m., Absecon police responded to Clayton Way in Absecon in reference to a 911 call of stabbing. Upon response, the victim, whose name is Kenneth Fenwick Jr., was located suffering from an apparent stab wound. An autopsy concluded that he died as a result of that stab wound, which was one puncture wound to the chest directly above the heart, and died as a result of that. A weapon was found on the scene, a large kitchen knife, 12 inches in total in length, with the blade about 7 inches. There was blood on that knife that's pending further analysis. The defendant was located in the area. She's known to, if not fully, known to reside part-time and often visit that area, which is believed to be the home of her father. The defendant was located, there was apparent blood on her clothing. She had made contradictory statements regarding her involvement to neighbors, and she ultimately, when given the opportunity, waived her Miranda rights, spoke to law enforcement, and denied having anything to do with the stabbing, and attempted to blame it on another individual. There was one other person present, that is the defendant's father. He did not have the same biological evidence on him that the defendant did. He provided a statement which indicated that he had nothing to do with the death of Mr. Fenwick. Surveillance video covers the apartment in question and makes clear that the defendant was in the building, or excuse me, was in the apartment at the time. Some other body camera evidence that was turned over to the defense also corroborates the neighbor's statements as to what the defendant did in the time immediately after the murder.
That this is a case that would have more appropriately been charged either as aggravated manslaughter or second-degree reckless. And just briefly, with respect to Mr. McKelvey's indication that Ms. Bass was found with blood on her clothing, there is an indication in the police reports indicating that at the time the police arrived, that Ms. Bass was standing over, essentially with clothing, attempting to tend to the wound on the victim. So based on that, it's clear that there would be blood on the clothing that she was trying to tend to him.
Pretrial detention of defendant is hereby ordered. My reasons for this decision are as follows. The nature and circumstances of the offense is charged. This was a particularly violent event and set of events leading to the near immediate death of the victim at the time. Defendant's departure from the scene also raises the risk of flight. The court has considered the weight of the evidence against the defendant, considering admissibility issues, including personal observations of law enforcement, statement of witnesses, statement of the defendant, video evidence, and physical evidence, specifically the recovered weapon, biological and forensic evidence at the scene, and blood stains on the defendant. The court has also considered the history and characteristics of the defendant, noting the defendant's strong family support both in court and in the community. However, the court has also noted the defendant's criminal history is reflected in the PSA, noting mostly DP offenses with very little prior violence, however, a record which is rather extensive. The court has also considered at the time of the offense here that the defendant was on release for DP level obstruction and shoplifting charges. The court has also considered the nature and seriousness of the danger to any of the persons of the community posed by the defendant's release, namely, the defendant's recent resort to extreme violence indicates a significant danger to the community. The court has also considered the nature and seriousness of the risk of obstructing or attempting to obstruct the criminal justice process posed by the defendant's release, namely, the potential for witness intimidation given the defendant's prior history. The The court has also considered the release recommendation of pretrial services using the risk assessment instrument, where release was not recommended. The court has considered, weighed, and balanced the recommendation of non-release. While not dispositive to the court's determinations here, the recommendation has been afforded significant weight. The defendant has not overcome the presumption of detention for this offense, for which the potential life sentence attaches upon conviction by credible preponderance of the evidence. As such, detention is warranted. Moreover, the defendant's conduct in this case bespeaks a clear danger to the community while first appearances occurred. Thank you, counsel.